It's a major victory for gun owners because the court has effectively done here is tossed out the old standard, which is any non-violent felony conviction means you're disarmed for life. And instead, they're applying the Bruin decision the way Clarence Thomas expected, guys. Watch this video and join the fight. Hey guys, Aaron Dorr here with a major legal update for gun owners watching across our various state platforms. You know, for a long time, especially in red America, the fight for gun rights was somewhat simple. Pass constitutional carry, pass stand your ground law, defeat universal background checks, defeat red flag laws. And that was kind of where the gun rights community has been for the last 15 years across the country. But those days are changing now. And these days, the fight for gun rights, especially in red states, which have accomplished these goals, is expanding to new frontiers because in the fight for gun rights, there is no neutral. We're either losing ground or we're gaining ground. There's no just static neutral in between, mostly because our enemies are never going to stop trying to weaken our right to keep and bear arms. And one of the issues that has been backburnered for these last 10 or 15 years, for the most part, has to do with prohibited persons receiving their gun rights back. We get tons of calls here at the office from gun owners who have a misdemeanor conviction or a non-violent felony conviction who want to know what's it going to take for us to get our gun rights back, both individually from clemency from the governor or at the statewide level. When are we going to pass a law that will allow me to have my gun rights restored to me? And it's been a back-burnered issue, as I said, for a very long time. But those days are changing. And we have always held here that a non-violent felony conviction should not result in a lifetime gun ban. And we have caught crap for years for saying that, from the left, other gun rights organizations, the media, all fear-mongering, saying you're trying to arm violent criminals. But of course, that's ridiculous. Our point has always been that a single mom, let's say, who steals food from Walmart one too many times and gets a felony conviction, while she should make that right, that should not make her unarmed and helpless for the rest of her life. And there's many examples like that. The good news now is that after a major court victory just a couple of days ago in the Third Circuit, we are now going to see a lot more attention given to the issue of what allows the government to disarm somebody for a lifetime. And guys, it's going to be a major advancement in gun rights over the next 10 to 15 years as all of the courts digest and unpack what the Bruin decision means from last year. So I'm going to break down this decision from the Third Circuit yesterday. I have the case on the other screen. I'm going to read some of the major quotes. You're going to love what you're about to hear. I'm here to tell you right now that the fight for gun rights is moving to the right as we go forward. What was kind of contained to constitutional carry, stand your ground law, rolling back, gun control, we've accomplished that in red states. And now these states are going to begin to go further to the right. And we're very happy to be leading that fight for gun owners. So the case here is Bryan Range versus United States. It was in the Third Circuit Court of Appeals. And the docket number, for those who want to look it up, is 21-2835. Now, first, I want to kind of explain how the federal court process works for those who aren't sure what I'm talking about. So in the federal court process, you have the lower district court level. That's where all of your original federal lawsuits are heard. So you have the district court judge. And then after that, if that case is appealed, it goes to the circuit court. And then above that is the United States Supreme Court. So 3 levels within the federal court process. Bryan Range brought a suit in the federal courts in Pennsylvania because back in 1995, Mr. Range lied on a food stamp application, and as a result of falsifying his income, received $2,500 in welfare food stamps that he should not have received from the state of Pennsylvania. And he was caught for doing that, and he was convicted, or he admitted to it, whatever the process was. And as a result, he received 3 years of probation. But in Pennsylvania, for doing that, he could have served 5 years in prison. And as you guys know, and gals know from buying firearms at a dealer, the form will ask you, are you a felon, and or have you been convicted of a crime that could have resulted in you serving over a year in prison? So Mr. Range obviously meets that criteria. He could have served 5 years in prison for this crime. Instead, he served no time, had 3 years of probation. He then tried to buy a gun and could not do so, and realized that he was a prohibited person, and realized that when he pled guilty, that meant he could never own firearms again. And so Mr. Range sued the government over this in the district court, and the district court judge found against him. Now, it's very common, just to be clear. From there, Mr. Range appealed to a 3-judge panel with the Third Circuit. That's kind of it's circuit court, but it's only 3 judges. The 3-judge panel also ruled against him, and from there, Mr. Range appealed to the full circuit court, which is 14 judges. And that is the body which gave this opinion just a couple of days ago. It's called an Onbank Decision, which means all the judges in that circuit weighed in on this decision. And the court held an 11-4 decision that the government may not, here's the main thing, the government may not disarm somebody for a lifetime for non-violent misdemeanor and felony crimes. And this is going to have seismic implications in the fight for gun rights in court, but also in legislative bodies across America, because for a generation or more now, it's always been kind of that line. If you have a felony conviction, you cannot own firearms. And let's be honest, a lot of people in the gun rights community, not our audience, but others, and a lot of people who are pro-gun in the legislative bodies have always kind of held this, look down our nose at people with a felony conviction and never wanted to fight to restore their gun rights. And at a certain point, I get it. I'm raising my children to obey the law, and I'd be very displeased if they got a felony conviction. But my personal morality and what my wife and I are giving to our children is not a standard for public policy. And people make mistakes, and people make felony level mistakes. But those mistakes, if they're nonviolent, should not result in a lifetime gun ban. And now what we're seeing is a court precedent that is backing this up. Before I break down the case, I want to explain the process. So we have this opinion now from the Third Circuit. That does not mean it's the end of the story. So the government has the ability to appeal this matter now to the Supreme Court, and they might, and or other circuit courts across the country, we've got a bunch of them, could weigh in the opposite direction. They can give an opposing precedent, and you'd have these conflicting opinions from various circuit courts. So we're not done by any means with this issue. But my point is that we are on a process now, which is moving to the right as we digest and implement last year's Bruin decision from the United States Supreme Court. So there's 3 main takeaways that I want to leave you with as we talk about what happened in this court decision. The first one is the government's primary assertion, which was that Mr. Range could not own a firearm because he was not one of the people who was covered by the Second Amendment because he was a criminal. And that's the problem. A simplistic view of this, you would say, well, yeah, he's a criminal. He shouldn't have firearms. But in this day and age, when the federal government and state governments and judges across the land are weaponizing leftist ideology against all of us, it is a lot easier to become a criminal these days than ever before. And in many cases, that can be a declaration someone's mentally unwell with no adjudication in court, or it could be you've been red flagged and deemed a criminal with no conviction in court. And again, we all know it's easier now than ever before for the left to turn to you and say, you're a criminal, and find some judge somewhere to deem you that. And that's the government's position. If you have been deemed a criminal, no matter how, no matter what the facts are, even if there wasn't a conviction, as is the case in a red flag gun seizure, you lose the protection the Second Amendment provides. And they claim that the country's historical precedent backed this up. And the Third Circuit soundly rejected that assertion. Here's the quote. It's a little bit long. Bear with me. They say, at root, the government's claim that only law-abiding citizens are protected by the Second Amendment devolves authority to legislators to decide whom to exclude from those protected people. We reject that approach because such extreme deference gives legislatures unreviewable power to manipulate the Second Amendment by choosing such a label. So I'm going to break that down for you. What they're saying is that we have to realize, they're saying as judges, that in certain states, especially in blue states right now, the state assemblies, the state bodies are deeming all kinds of people to be criminals simply by labeling them as such. And that this is the idea they're going to lose the protection of the Second Amendment because of that label is not constitutional. Again, it says we reject that approach because such extreme deference gives legislatures unreviewable power to manipulate the Second Amendment by choosing such a label. Fantastic legal posturing here from the Third Circuit. They also say, and that deference would contravene Heller's reasoning that the enshrinement of constitutional rights necessarily takes certain policy choices off the table. What does that mean? Well, what they're saying is that in Heller, the Supreme Court said that because this is a fundamental right to keep and bear arms, some policy objectives are off the table. In other words, some of the laws the crazy left wants to pass are simply unconstitutional. And just because they can get a woke leftist legislature somewhere on the East Coast, on the West Coast, or somewhere in between to pass a gun control law does not mean that law is constitutional. This is a seismic opinion from this court, because if we acknowledge the fact then that these chambers might be passing legislation which is blatantly unconstitutional, then a whole bunch of this house of cards could collapse, as is the case here with non-violent felony convictions. Takeaway number 2 on this, equally as important. The government tried to claim that they met the Bruin historical precedent test because they said that the felon with a gun statute was passed by the Congress in 1961. You back up for a moment. In the Bruin decision from last year, the court held that any gun control laws had to show that they met the historical use of firearms in this country. In other words, if the government had not outlawed these things way back in the day, that historical precedent was going to be the guiding principle, the binding principle on any future gun control laws and their constitutionality. And so what the government said here is that, yeah, we did that. We checked the box. Because way back in 1961, Congress said that felons cannot possess a firearm. And that's become part of the war right now in courtrooms across America after Bruen. How long? How far back must we look to establish this historical precedent? It's a great question. And in this case, the court was very clear that whatever that date is, it damn sure isn't 1961. They said, quote, whatever time frame the Supreme Court may establish in a future case, we are confident that a law passed in 1961, some 170 years after the Second Amendment's ratification and nearly a century after the 14th Amendment ratification, falls well short of longstanding for purposes of demarcating the scope of a constitutional right. In conclusion, the 1961 iteration of 922G subsection 1 does not satisfy the government's burden. So in English, what the court is saying is that we don't know exactly how far back we have to look for historical precedent to satisfy the Bruin standard. But by goodness, it's not just 1961. It's got to be way back before that. So they are saying right here that the Congress's decision in 1961 in 922G subsection 1 to say that all felons with firearms are criminals does not pass the test. This is a major, major victory, folks. This means that all kinds of people who have been summarily disarmed in our entire lifetime may not have to be that way for the rest of their life. It's a massive decision from the Third Circuit. So point number one was that criminals, by the government's definition, are blatantly not covered by the 2A. The court rejected that. Number two, the government says that 1961 is certainly old enough to count as historical precedent. The court rejected that as well. And the third big issue that we talked about in this case deals with their upholding the end of means-end scrutiny. What does that mean? Well, in layman's terms, and that's what I am, I'm not a lawyer. So in layman's terms, prior to Bruen from last year, the court has always maintained a means-end scrutiny standard. And what that basically means in English is that the court held unto itself the right to weigh the Second Amendment versus the needs of public safety. And that let them decide where to draw the line on what gun control was constitutional and what was unconstitutional. But as we all know, what that did was allow individual judges to insert massive amounts of their own personal bias against the Second Amendment into their opinions. Basically, it was an open door blank check. So they could say, yes, here's the Second Amendment, and it's heavy, and it says this, and it means this. But, that key word, right? That big, big word. But we have the interest of public safety over here. And so, therefore, I declare that this gun law is constitutional. This gun control law is constitutional because we have to balance your rights with public safety. And what Bruen did was took a sledgehammer to that standard. And they said, in their opinion, or in that decision, because there's been too much abuse. There's just been too much blatant abuse where judges were allowed to interject their own bias in between Second Amendment freedom and the right to, or the need to balance public safety. If it's that wide open, then anybody could abuse it. The court said in this decision, they said Bruen rejected this approach as one step too many. The Supreme Court declared Heller and McDonald, the cases of 2008 and 2010, do not support applying means-end scrutiny in the Second Amendment context. Instead, those cases teach that here's the key part, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And so only if a firearm regulation is consistent with this nation's historical tradition may court conclude that the individual's conduct falls outside of that scope. Now, again, this was a part of the Bruin decision, but what you're seeing here is the circuit courts all across the country now having to interact with and apply that standard when they issue their opinions. In fact, in this Third Circuit Court case, they said that prior to Bruen, we used means-end scrutiny as our standard. And they all but said we would have done it again here, but because Bruen tossed that out, here is our new standard. And using that new standard, which is that the two-way covers us for all normal conduct, they ruled that a non-violent felony conviction is not grounds for someone to lose their rights for the rest of their life. So, guys, I hope you can see that there's a tremendous amount of incredible advancement and protection of our gun rights in this opinion. And it's not done. As I said, this case can be appealed by the government, and it probably will. Other circuits could weigh in the opposite direction, and they might. But all of these cases are heading back up to the Supreme Court for more adjudication. And given the current court's makeup, there's never been a better time in our lives to have these cases heard by the Supreme Court. This same opinion, this same notion, rather, of the historical precedent and the use of firearms is why you're seeing all kinds of gun control laws being struck down all across the country. Gun laws that ban firearms from those age 18 to 20, those are collapsing. Magazine ban limits in Maryland, those are collapsing. Assault weapons ban cases are being heard right now all across the country, and there's many more cases like that because the court now has to interact with the idea that the Bruin decision requires them to weigh in that calculus the historical use of firearms in this country, guys. It's a great time to be involved in the fight for gun rights. We're so happy to be involved in that, both in our state capitals and in our federal court system. There's a lot of victories coming down the road. And the reason for it is very simple. The reason for this is very simple. You can love him, you can hate him, somewhere in between, makes no difference to me. But one thing that Trump did in the White House was stacked the federal courts and the Supreme Court with constitutional justices. And there was, by my recollection, 115 or 120 vacancies on the federal bench when Barack Obama walked out of the White House. And President Trump got in the White House and he turned to the Federalist Society, the very hyper conservative justice club in Washington, D.C. And he just told them, give me a list. Give me a list. And he appointed and nominated hundreds of conservative judges to our federal courts, in addition to the Supreme Court. And we're seeing this pay off in a major, major way. And that's not going to stop. These guys and gals will be on the bench in some cases for 20 years, 30 years, 40 years. They're going to be around for a long time. And so while we continue to fight in state capitals for our members, the fight in courthouses will be a major aspect, even more than it has been so far going forward, because of the impact of Bruen and all these new guys and gals that we have in the federal court process. So guys, thanks a lot for watching the video. Get involved in the fight. Join up, hitting the link below. Share our video online. And we'll keep you guys informed. Stay free.